You're there to communicate dispassionately that you are not being excessive as a prosecutor, that this person represents a danger, that you're cool, calm, and collected in your evaluation of the evidence and in that opinion, and then asking the court to essentially say that this is a continuing danger to the community, and there is nothing the court can do to make him safe and secure from victimizing other individuals. Great job.
Bob, what did you make of what the judge said? He had one question about whether or not there was a companion civil suit. Do you think that was an appropriate question to ask in a criminal case? And where do you think that signals he may be leaning?
It is an appropriate question to ask, and I think, honestly, he was just kind of like trimming the prosecutor a little bit. Like, so this isn't somebody, the prosecutor's trying to make an argument, and the court's trying to understand. Well, you said that they didn't go to, they're just doing this for purposes of the criminal case, not civil case. Yet, I have in the record that they went to a civil attorney, and the prosecutor cleared up how that was, because this will be a major motive or an attack down the line, one way or the other, where the defense is going to say this is a money grab.
He wants that to be considered by this judge. How often is that looked at when we're thinking about or looking at something in terms of bail, but not a trial in front of a jury?
I think it's a very important thing as a defense attorney. And by the way, as prosecutors, it always makes me laugh when prosecutors poo-poo it, because we had a team of polygraph experts ourselves that we use for investigative purposes. It's an investigative tool. So when you hear that it's scientifically unreliable and maybe not admissible, it certainly isn't in New Jersey admissible in a court of law or at a trial, the fact that the defendant was willing to take it and the fact that he passed it, to me, is a very significant factor. Now, I agree with the prosecutor. I want to see the data, and I want to have an opportunity at a crack to have my polygraph person examine him to make sure it's on the up and up. But I think it's a significant factor the defendant was willing to do it and passed it.
Well, what about the fact that, the prosecution refers to the 87 letters of support that the defense has provided? 87 letters. Is that not a lot of letters in your experience or not, Bob? And what do you think about that many letters of support? Should it make a difference in a bond hearing?
It should make a difference. It's, it's funny, the prosecutor, again, poo-pooed it, and I get it. That's what the prosecutor's there to do. But there is literally a jury charge that says character evidence is admissible at trial. You could go to trial, and on character evidence alone, the jury is charged. You could find a person not guilty on that evidence alone. So remember, this hearing isn't just whether or not he's going to be a danger to the community. They do have a standard of probable cause to show that he's guilty or that there's evidence to support the charges here. And so character evidence is relevant to that determination. There's nothing inappropriate. It's often used, and the prosecutor's denial of it, I think, was inartful.
Interesting. What a position to take on that, Bob.